Good morning. Thank you for joining us. My name is Amy Lee Hogan Simonovich, and I am an attorney with Ridge and Downs, and this is my colleague Karen Connolly. And
Hello.
what we're going to do this morning is start with a short PowerPoint presentation. Our whole discussion today shouldn't take more than 15 minutes. I'm going to go ahead and share my screen. You'll notice that the video is all off for the attendees, and you are all muted. So if you have any questions, there is a question and answer button. There's a chat function. So just let us know if there's anything we can answer for you. With that, I'm going to go ahead and share my screen so that you can watch our PowerPoint. So Ridge and Downs focuses in workers' compensation, personal injury, and FELA injuries, which are railroad worker injuries. And so if anyone has any questions about other work-related injury matters, please don't hesitate to let us know. But what you really came here today to hear more about is an amendment to the Illinois Public Employee Disability Act in response to the COVID-19 pandemic. So what is the Public Employee Disability Act, better known as PEDA? And this law provides that when an eligible employee suffers an injury in the line of duty, which causes him to be unable to perform his duties, he shall continue to be paid as he was before the injury for no longer than 1 year. I will note that a common question that we get with regards to the 1 year is whether it is 1 year from the date of injury, and it is not 1 calendar year from your date of injury. It is 1 year when you use it for that injury. So if you use, 3 months and then you go back to light duty and then you need to go back on it again, that's okay. It does not have to be a consecutive 1 year from your date of injury. The next thing we have to define is what is meant by eligible employees. So the Public Employee Disability Act covers full or part-time correctional officers, full or part-time employees of the Department of Corrections, full or part-time employees of the Prisoners Review Board, full or part-time employees of the Department of Human Services if they work in a correctional facility or developmental disability facility, full or part-time law enforcement officer, full-time firefighter, including paramedics. So you'll note that for that particular category, it is the only one that is not part-time. It has to be full-time. There's also a limit with regards to injuries sustained by correctional and human services employees, that the injury must be the result or indirect result of inmate or resident violence. All other injuries are line of duty injuries to be covered. So Karen, can you explain to us what the COVID-19 amendment did to the PEDA Act?
Oh, of course. The COVID-19 amendment extends the 1 year time period during which an eligible employee receives full pay following a work-related injury by 60 days. That extension is available when the circumstances directly or indirectly attributable to COVID-19 hinder the recovery for an employee. And that hindering the recovery must occur between March 9th and December 31st of 2020. And you may ask yourself, how could COVID-19 delay my recovery? And this generally is going to apply to a non-COVID related delay in treatment, to a non-COVID related injury. If you have, say, a knee injury or a back injury, COVID-19 could delay your surgery. There were several months where no elective surgeries were being performed in the state of Illinois. Many physical therapies have been canceled for the duration of the pandemic. You may not be able to get a referral for a second opinion in order to see whether or not you need surgery. You may not be able to get in to see your doctors, or it may take a substantially longer time period to see the doctors in order to recover from your injury and allow yourself to get back to work. Now, there's probably as many other examples as one could come up with, because it's going to be an individual assessment for each person. But that is generally how, if you don't have COVID-19, how COVID-19 could affect your ability to return back to work from a work injury.
So we have a bonus question here. What should I do if my recovery is hindered due to COVID-19? A, nothing. My employer is really understanding. B, why should I have to do anything? Shouldn't that be somebody else's responsibility? C, I'll just say COVID and my employer will pay me for another 2 months. Isn't it automatic? And D, get proof in writing from the medical providers stating that your recovery was delayed because of COVID-19 related delays. Obviously, the correct answer is D. Get proof in writing now that your recovery was delayed because of COVID-19 and its impact on the healthcare system. This isn't something that you're going to be wanting to get proof of, 6 months from now when you need your leave extended. It's really something that you want to do right now while it's fresh and easy to identify exactly what has just happened.
I've had a number of clients that have just, said to their doctor, can you please put in writing that you've canceled all appointments for the month of May? And doctors seem to be very happy to do that, send over a little note. And, that was applicable to why other people, weren't able to get an off work slip, let's say. But it's very easy, and doctors have been very understanding. And we have a bonus quiz question.
So what if my recovery is delayed because I was exposed to or tested positive for COVID-19? So as long as a medical professional establishes that your recovery was hindered as a direct or indirect result of COVID-19, it fits the definition established in the amendment. So what this is talking about is your recovery can be delayed because of COVID's impact on the healthcare system, or it can be delayed because you yourself was exposed to or contracted COVID. Either one of those reasons qualifies.
And we would like to just do a little review. Some of you may have attended our earlier webinar that talked about the COVID-19 amendment to the Occupational Disability or Occupational Disease Act. And we wanted to do a short review. What if you think you contracted COVID-19 due to a work-related exposure? First of all, the amendment to the Occupational Disease Act talks about first responders. What a first responder is really exactly the same as an eligible employee under PEDA. The amendment created a presumption that if a first responder was exposed or contracted COVID-19, it was related to their work activities. While your employer can rebut this presumption, that means prove that that you're not automatically entitled to it, you can still prove that you had or contracted COVID-19 due to a work-related exposure and recover benefits under the Workers' Compensation or Occupational Disease Act.
So if you'd like more information about contracting COVID-19 in the workplace, you can watch our prior webinar on that. It is up on the Ridge Downs YouTube channel. If you have any trouble finding it, don't hesitate to reach out to us. I have our contact information up here. There's emails for Karen and I. We have the ridgedowns.com website. We also are on Facebook at Ridge Downs, as well as Twitter at Ridge Downs. If you want to follow us on there, it's a great place to get updates like this on what changes are happening in the area of workers' comp and personal injury, and learn more about how your rights can be affected. With that, I'm going to stop the screen share so that we can take some questions.
And please feel free, you can certainly ask regarding this the COVID-19 PEDA amendment, but anything else with respect to workers' compensation or COVID-19 and work, we're happy to try and answer for you.
Okay, so I'm gonna go ahead and take our first question from our Q&A box. Does my delay have to be 60 days?
I can answer that. No, it does not have to be. It's any time within that 60-day period. And, you know, if it's 2 weeks, they're going to have to pay you for an additional 2 weeks. If it's 60 days, they're going to have to pay you for an additional 60 days. But it's not going to be an automatic 60 days, and it certainly can be less than that.
And there was a companion question to that one, Karen. What if my delay is longer than 60 days?
Well, unfortunately, if your delay is longer than 60 days, you're only going to be covered for an additional 60 days with PEDA benefits. Under the Workers' Compensation Act, when someone is unable to work because of a work-related injury, they're entitled to what's called temporary total disability benefits. And that's 2/3 of your average weekly wage payable during the time that you're unable to work. That can last as long as your disability lasts.
Okay. All right, so our next question was, what is a line of duty injury? So it's a very broad thing in terms of what is covered for your job duties when you're performing an act that arises and in the course of your job duties. So, I mean, if there was a specific example, I mean, I could probably answer that a little more specifically on a case-by-case basis. But again, just remember that if you're in corrections, it's going to be a little bit different. It has to be the result of inmate violence. Other areas in terms of firefighters and police, it's just line of duty injuries sustained in the course of performing your job duties. Karen, do you have anything to add for that one?
I think that it can be thought of as something connected to police work or fire work. You know, if you're just standing there, you know, in the driveway of the fire department and something, you know, like someone hit a baseball and it came and hit you in the head, that probably isn't going to be a duty related injury. It's just, it might be a fall under workers' compensation, but it's not a duty related injury. It's certainly broader than arresting a suspect or fighting a fire. It's far broader than that, but it's not every single thing that happens while you're at work.
So one of the other things that I always like to bring up when we talk about PEDA is my friendly reminder that if you are receiving your PEDA benefits, you cannot be working any secondary employment or you would forfeit those PEDA benefits. I like to give that disclaimer as much as I can whenever we are giving any sort of discussion on PEDA. It's important to understand that you cannot, even if you're physically capable, the secondary job is within your light duty restrictions, you still can't, you know, do that job. So keep that in mind as my friendly PSA about PEDA benefits. Okay. I don't see any other questions. Karen, is there anything else you want to add before we sign off?
No, I think we've covered everything. Thank you everyone for joining us today, and I hope you found it informative.
Yeah, thanks everybody. Join us next time.